Lordship, I beg to mention item number 4.
You're appearing for?
For petitioner. It's come after 2 weeks, Your Lordship.
Why? All these matters is now, this is a matter of 21. Now we are in 24. If we go on like this, then we'll go over to 25, then 26.
No,
by the time
we seek just accommodation, Your Lordship.
Try to get better disposed of.
Yes.
Just cannot just keep on hanging. What is the matter about?
That gradationless, my lord.
Gradationless.
Lordship.
On pre-made petitioner, this is matter of 2 weeks.
Deeply obliged.
Lordship.
From supplement causes, item number 1.
Your Lordship, I pray this matter may be taken up at the end of the board, Your Lordship.
Lordship, the cost has been imposed, and that the final last date is 18, Lordship, to be paid. So I am applicant is praying herein for some more time in order to avail other legal remedies, Lordship. So praying here is for met for 60 days, Lordship. More time.
Mr. Padia,
Yes, Lordship.
notice has to go. Notice has to go to all these.
No, all these were represented by.
Are you representing all?
Yes, Lordship. They have an advocate in the contempt
Lordship.
proceeding.
Yes, then
This is
what is
only
there to
prayer
oppose?
for a time, Lordship. If I got a relief from other
Yeah.
by taking other
Cannot be
legal
too-
recourse,
We cannot be too rigid.
yes, Lordship.
Your Lordship, liberty may be given to file an objection pertaining to the
What
case.
objection? What objection?
In a disposed of
Day
matter,
after
only
tomorrow
time is
Day after tomorrow is the deadline.
Lordship.
Why you want it at the end of the board?
Your Lordship, because the DSG had some important submissions, Lordship.
We'll wait for it.
Lordship.
End of the board.
Much obliged, Lordship.
Daily list, item number 1.
May it please your Lordship. Lordship, this is the case whether it will be filed before under the old code or under the new code. Lordship, yesterday Lordship will recall that question is to be determined by the division bench, your Lordship. I don't know, your Lordship.
I think we'll have to wait for that.
Lordship, in my humble and respectful submission, your Lordship, since your Lordship was a member of the bench, your Lordship, I would respectfully submit that let us await the decision of the division bench, your Lordship.
When is the matter fixed? The division bench?
Lordship, just a minute, Lordship. $29.7, your Lordship. 29.7. Monday, your Lordship.
We'll
That is
fix this on 31st then?
Lordship, yes.
Not till then, if I may pray.
Lordship, no interim order can be passed, Lordship.
Yeah, because it's a question
That
of
has to be decided
question of
first,
procedure. Because
My
again,
lord, yes.
even interim relief, so under which provision to be passed?
Lordship.
My lord.
It's quite difficult. Yeah. But these are transition period,
My lord.
so we just have to bear with it.
It'll take some time, Your Lordship. It'll take some time.
More or less, you see, I've noticed some, Mr. Shura, you said you produce some High Court, Delhi High Court judgment.
Lordship, we went to that website of the Punjab and Haryana High Court, Your Lordship. It is not there in the website, Your Lordship. It came out only in the lib law, Your Lordship.
I have a judgment of the Punjab, but not. It's not. It deals with the same issue, but not necessarily in bail matters. That
No,
is
no,
with
in,
regard to the trial.
not on bail matter, Your Lordship. On different issue, Your Lordship. Lordship was correct, Lordship. Yes.
But I think.
And even the Delhi High Court also, Delhi High Court
I
also,
don't
Your
have the
Lordship.
judgment.
But we couldn't take out, Your Lordship, because they have not uploaded, Your Lordship. That is the problem we are facing, Your Lordship. Otherwise, you could have placed it or do a judgment, Your Lordship.
I have the judgment with me. I can share it with you if you want to.
If Lordship can share that with us.
Just a moment.
Padahal kawai ka family sa.
To apply yung
Itu kah, waktu itu buat kencing. Lordship will not burden Your Lordship. Will collect from the.
yes, sir. Fine.
Will collect from her, Your Lordship. Will not burden Your Lordship.
On pre-made by the parties on the ground. Yeah.
Can it come on 31st, Your Lordship?
Mr. Andy Shulai, London AG, has submitted that the issue which is required to be determined herein, particularly the procedural aspect in the light of the coming into force of the new criminal code. That is, what is the name of the code?
BNSS, Your Lordship, in short.
I full look to that is BNSS. A similar issue is pending before a division bench of this court. And as such, it is submitted that this matter may be kept in abeyance to await the decision of the division bench in this regard. Accordingly, as prayed for, list this matter on 31st.
31st.
That's fine.
Apply, Your Lordship.
Item number 2.
Please, Lordship. I'm praying that this matter may come at the end of the board, Lordship.
Just a moment.
My lord, this is also pertaining to the similar case. My lord. My lord,
the issue is to be decided then.
the Honorable Delhi High Court as well as Punjab High Court, my lord, Punjab and Haryana High Court, my lord, both the judgments are with me, my lord. I'm just placing it on the
Mr. Sunkan, we were discussing it
My
earlier.
lord, that was
You could have offered at least. You are an officer of the court.
my lord.
Anyway, this court will go through it.
Yes. And one small submission, my lord, because in those two cases, my lord, the honorable high courts, different high courts, my lord, they have already decided that those pending cases, the old act will, old code will be applicable. And one alternative submission is, my lord, why the old act should be applicable, my lord, is because all the three CRPC, IPC and my lord Evidence Act, this comes in set. One code has a reference of the other. Now, in case the cases which are registered earlier in old act and old code, and if new code is made applicable, my lord, there will be in many places which we cannot at present we cannot understand where it may affect. But in my understanding, my lord, if for cases which are pending prior to coming into BNSS, my lord, if the BNSS is made applicable in all those cases, my lord, it will create a lot of confusions, my lord, and in many areas, my lord, it will create difficulties, my lord.
True. That is, like I said, this is an area which is, well, perhaps new to us. We will have to get over it.
Yes.
But in due course, everything will be clarified.
Right, my lord.
For example, if I recall, there's also an controversy as regard jurisdiction, where in the court, CRPC, the word or the code of the Metropolitan Magistrate is there. Here in the new court, it's not there. Now we don't know.
Yes.
The code of Assistant Sessions Judge is there in the old code. Here it is not there. So who will assume jurisdiction in which area? So those are things that needs to be sorted out. So we'll take up on 31st.
Item number 3.
Lord, item number 3, my lord, I'll pray for some time. My lord, here we are to produce some records, my lord. On the last occasion when the matter was taken up. My lord, I have written to the department. My lord, will require some more time.
Lordship, if Lordship recollect, this is that teacher matter, Lordship, where the great petitioner was appointed since 2006, Lordship. And the
With
appointment
regard to
was given year after year,
old
Lordship.
pension
My lord,
scheme and new pension
substituted, no,
scheme.
lord. She was always there in the office only as a substitute teacher, my lord, as and when the vacancy.
That is their
raises.
contention, Lordship. But,
Yes, my lord. This is she's the niece of, my lord, the principal Gail Indo, my
yes,
lord.
Lordship.
Who was appointed as a substitute teacher.
Sir, every appointment, all appointments are as a substitute teacher, my lord. So
that is their
actually,
contention, Lordship.
Yes,
But
that is their
that is
So,
record from the
the
records
record.
made available by the petitioner. That itself shows, my lord.
Lordship has directed them to produce the records of that principal. Lordship.
So, lord, I require some more time.
The record as regard the services of the
My lord, yes.
headmaster, whose name is principal.
Principal, Lordship, who voluntarily retired, Lordship, and the petitioner was appointed in his place.
But we'll see how
That
whether
mode
it
of,
was formally
no.
adopted or not. We'll have to see. So when
My lord, I'll pray for some more time because it is to come from.
They've already taken 3 weeks' time, Lordship.
Yes, my lord. I have already written to them. My lord,
you should remind them. Nowadays, distance is not a problem.
no, because my lord, it's an old file. They'll have to look for the file and all.
2 weeks.
Short date, my lord. Short date, maybe.
2 weeks then.
Otherwise, the petitioner has no case.
Mr. K.P. Bhattacharjee, Larat GA, has opted that the records as called for by this court could not be produced, and as such, it is prayed that some more time may be allowed for the same to be placed before this court. Accordingly, on preamble, matters adjourned, let's the same after 2 weeks.
My lord.
Be sure, 2 weeks means 2 weeks. Otherwise, we'll
My lord,
see.
may I pray, my lord, may I pray for 3 weeks so that I am able to produce it, my lord, so that I don't have to take time over and
This
again.
is matter up to 3 weeks. It is needless to say, no further time will be allowed
My lord.
after the set date.
Deeply obliged, Lordship.
Item number 5.
Lord, item 7, my lord, before my friend begins. My lord, in my respectful submission, my lord, this matter is already in fractures. My lord, new appointment is already made pursuant to the directions of this honorable court, my lord. Advertisement was floated in which the review petitioner also participated in the selection process, my lord. She was unsuccessful. And my lord, in the meantime, the appointment is already issued, my lord. On the 10th, the appointment is issued, and on the 11th, the new incumbent has already joined. So, my lord, the third party right is already in existence, my lord, as on date.
Lordship, two things, my lord. Firstly, if Lordship kindly recalls, I had mentioned this matter on Friday, that is 12th, saying that there are, my instructions are that there are developments, advertisement has been reissued, that interviews have also been conducted. My friend had appeared and objected to any sort of intervention on that day. He could have placed before this honorable court that previous day itself, if I'm not mistaken, his client.
I cannot have it.
Very
Here
well.
I
Very
was
well. Very well.
appraised
This
by my
shows,
learned friend, my lord.
I would say this shows a lack of bona fides, my lord. Number one. Number two, my lord, we had filed a miscase. We had filed a miscase on Friday and sought Lordship's permission for some interim protection. Lordship, in his wisdom, said that let the matter come up on Tuesday today. Now, if my friend is saying the matter has become infructuous, let him place it on record by tomorrow or day after.
Yes, you see, because I think we are all aware of the situation. You see, if you see, let's put it this way: after the passing of the judgment of this court,
yes, madam,
where rightly or wrongly,
yes, madam,
you see, the authorities are directed to float the advertisement and to start the selection process.
yes, madam. Lordship,
If in the meantime that has been done,
yes, madam,
till the period or till the date,
yes,
when this review petition was filed,
yes, madam,
then it has become, the whole process has become infructuous as far as you are concerned.
yes, madam,
But if it is a subsequent development,
yes, madam,
after the filing of this,
yes,
then
My lord will kindly appreciate the
in
fact,
fact, during the pendency of the review, this entire process has been conducted. Interviews were conducted on 9th of July. In the midst of hearing, I had already, the matter was already part heard by my lord. If Lordship recalls, I had made my submissions.
there is no stay order before this honorable court,
Very
my
well,
lord.
but there is a pendency. Matters sub
Mere
judice.
pendency, my lord. Can it obstruct, my lord?
tell me,
My lord.
when was the advertisement floated?
My lord, the advertisement was floated. I have submitted my affidavit, my lord.
Lordship, my
The
instruction.
23rd August 2023, last year, my lord.
Exactly. Last year, my lord.
Now, my lord, this is a case where the petitioner has participated.
Before
The review petitioner.
Before my lord passed his
She cannot
judgment.
blow hot and cold at the same time, my lord. If it was a question of review, she should have filed for the review immediately, my
Let
lord.
Mr. General have a say.
Lordship, before my lord had passed the judgment, my lord's judgment was passed on 26 2023. Soon thereafter, my lord. Soon thereafter.
26?
20 June 20th.
Okay,
20th June.
Fine.
2023. Soon thereafter, 2 months thereafter, the advertisement was issued. By then, review petition was already filed. Everyone was participating in that review petition, including the school. The school had entered appearance also.
Review petition?
In the review petition.
No, my lord, review petition was filed at a later stage with condonation of delay. What my friend is submitting.
There was condonation of delay, but the review, but
is making incorrect submissions.
the matter was sub judice. The matter was sub judice, and there was constant participation from everyone, including the school also. So school was well aware, my lord, of the pendency of the sub judice nature of the issue.
Just let me.
There has to be a clear direction from this honorable court that no selection process has to be proceeded with.
See, just a moment.
Yes, ma'am.
The date of decision was 20th
20th June 2023.
Okay. So,
Advertisement is issued on 23/8/2023, my lord. That is in the month of August. 2 months after.
advertisement, order, judgment.
Advertisement is issued on 23rd, which is enclosed with my affidavit, my lord. Now the advertisement is
Advertisement
also
23rd
23rd August
August
2023.
2023.
It is enclosed with my affidavit, my lord.
Okay, whatever the case may be. Now, pursuant to this advertisement,
Yes, ma'am.
many applicants have applied,
Yes, including the review petitioner.
including you.
Must have.
Then,
Master Nish, you should come clear, my lord.
My lord, I had participated because I had no other choice. I received a.
My lord, what is he submitting?
It's like Lordship will kindly appreciate. It's a fate to comply. If I don't participate and there is no positive out of.
Mr. General, look at your conduct.
Yes, ma'am.
Look at your conduct.
Yes, ma'am.
the order was passed on 20th June.
Yes, ma'am.
Between June and August,
Yes, ma'am.
there's a gap of 1 month or so.
2 months.
About 2 months.
1 month, one and a half, it doesn't matter.
Yes, ma'am.
But it has, it would have given you sufficient time to file a review petition if you are so advised.
Yes, ma'am.
You have failed to do so. Or take any recourse, even file an appeal for that matter.
Lordship, subject to correction, I humbly beg to differ. The review was filed before the advertisement, my lord.
No, my lord. It is
Subject to
incorrect.
correction, because I was not
You
the
file a review in,
I was not the original
It was
counsel,
filed
but subject.
after participating in the
Just-
selection.
So let's
This
let's
review.
ascertain the dates.
this review.
Review, my lord, was filed on 12th September, after the advertisement. 12th September.
Oh, this
That is what I'm saying.
is a 2023 matter. Okay.
Yes, ma'am.
So 12th September.
Yes, ma'am.
Then
I cannot escape the.
After participating.
I cannot escape the records, my lord. But the fact of the matter is, the fact.
we have to be fair to the process.
Absolutely, my lord. Fairness, my lord, will have to be extended to me also. I had filed a review petition, and in view of the pendency of the review petition, the advertisement was not acted upon for so long. Advertisement was in August last year, 23rd August last year.
That's beside the point. See, that's beside the point. A review petition was filed. No interim order was pressed for. Even if it is pressed, no interim order was passed.
Yes, ma'am.
So, I mean, you know very well. See, it's well settled that there is no bar for the procedure to be continued or to follow.
True, my lord.
So that is it. Now, in such a situation, when the procedure has been followed, advertisement was acted upon, okay, irrespective of the fact that you are also one of the the aspirants or applicant, whatever the case may be, that process is over now.
Yes.
In the meantime, the consideration of the review, the main ground being the issue of the advertisement. Now that has become redundant. I mean, tell me, what can this court do?
Lordship,
Can we upset the process now?
Lordship, in that case, if I can humbly request, my lord, that my friend has submitted that apparently appointments have also been issued. Let him put it on record, my lord. Let him put it on record. I'll also take instructions because I am also submitting in the dark as far as these developments are concerned, my lord. Let him put it on
You
record.
file your
My lord, my affidavit is very clear, my lord.
You've given all those details.
My lord, of course, my affidavit was filed earlier. This latest detail, the managing committee can submit, my lord.
If he's saying that,
my lord.
if he's saying that third-party interests have been created, let him put it on
Do
record.
it nationally. You see, once an
Absolutely. So let him.
is made, then
So even we know that for the next round of litigation, who to make parties, my lord.
My lord, the review petition.
fine. Let's do. Who's the managing committee?
My lord, she is for the managing committee.
You have made the appointment. Was it approved for you?
I am the petitioner, my lord.
And she's the appointee, my
Oh,
lord.
you're the petitioner.
Yes.
She has been
Who is the
appointed.
state?
State minister.
Has it
Lordship, as per my information, the interview was conducted on the 9th. But I'm not,
9 of what?
Of 9 of
July.
But I'm not aware, Lordship, whether
This year?
Last week.
This
Last
month.
week, my lord.
This month, Lordship.
Last week, immediately I filed a miss case.
Last week.
They said no, nothing is urgent.
But
Now,
I've not received,
and now matters become infructuous according to
Lordship, but I've not received any information whether the result has been declared or not.
See, Mr. General, I'm very sorry.
Yes, my lord.
Perhaps you did not make it clear enough to me the last time around.
Maybe fault is mine.
As far as the date is concerned.
Maybe fault is mine. My voice may not have been loud enough on that day.
Had you specifically indicate that it has happened in those
Right.
dates between 9, 10 or my impression always goes back
My lord,
to
in the review petition, my lord, because this is a fresh cause of action, my lord.
that's a different thing altogether. We're talking about the development which has happened thereafter. But anyway, now that's all academic now.
True, my lord. So let them put it on record, my lord. And
Bring it on record.
Please do. You bring on and your if there's any approval,
Yes.
do that,
Yes, sir. Yes, sir.
and then we'll see.
Yes.
Upon hearing the parties, this court is made to understand that pursuant to the order dated 26/2023 passed by this court, wherein a specific direction was issued to the concerned respondents to issue a to issue an advertisement for the post of assistant teacher in the, what's the school name of the school?
My lord, Rajabala High Secondary School, my lord.
Rajabala High Secondary School, comma, it appears that in the month of August 2023, said advertisement was issued, and on the selection process being initiated, a number of applicants had taken part in the process, including the review petitioner herein. It is also the submission, particularly of Mr. K.P. Bhattacharjee, that you are appearing for the
I am for the petitioner, my lord. In the original writ petition, I am the respondent here, my lord.
respondent. I oblique petitioner in the original writ petition, that as on date, the selection process has concluded and appointment of the successful candidate have also been made. Thanks. Ms. Ghosh, Leonard, counsel for the respondent managing committee, has also confirmed this fact and has submitted that. You say that the appointment has been made? Yes. Also submitted that the said appointment of the successful candidate has also been made. However, so as to bring the relevant records, bring the relevant facts on record, the parties, particularly the managing committee, respondent managing committee, and the state respondent, are called upon to file an affidavit to bring such facts to the notice of this court. Hello?
Lordship, if I can make please a small suggestion, my lord, very humble suggestion. If my friend can confirm that he is the one appointed, and that can be recorded, because I think his client is appointed.
No, my client is not appointed, my lord. New candidate is appointed.
We are talking about
no, because we were this whole exercise now is for the determining the identity of the
new appointee.
It's a new candidate.
Okay.
On the next date, we'll.
So once that is determined, like I said, we will close the chapter and then you have a fresh course of action.
Yes.
Whatever the case may be.
Yes.
This is
Who is
matter.
successful and was being appointed, we'll bring it on the next date.
This is matter of the 2 weeks.
Obliged.
Item number 8.
Yes, Mr. Pant.
Well, this matter, in fact, on the last few occasions, the prosecutor had considered that there is no piece of evidence against the petitioner accused, only except, Your Honor, my lord, that this accused person was absconded, my lord, limited to that extent, my lord. Otherwise, also, my lord.
This criminal petition, Lordship, is the prayer is to discharge the accused from the trial. Lordship, I have gone through the LC record, and there is no direct evidence against this accused person. It is all based on circumstantial evidence and also based on the information received. After the incident, Lordship, he was absconding, and thereafter the police, they were looking for him, but he was still remained absconding, and they went to his residence also to arrest him, but he managed to escape, and thereafter arrest of warrant was issued to him, and the he was not. The police could not find him, could not locate him. So the proclamation order was issued, and thereafter still he was absconding. And at one point of time, Lordship, on the basis of the information, the investigation, they got the information that he was hiding in one of the coal depot. So they went there to arrest him. They managed to catch him, but the crowd, they have intervened and they snatched him from the police, and he managed to escape again. So, and also there's no as per the statement of the accused person, arrested accused person, none of them, they have named him in their statement. So
where's the impute order?
Malbe, kindly come to page 104, my lord. Starts from 104, my lord.
Yes.
And as regards to my accused person, my lord, it is specified in page 115, my lord. 115, my lord. Second paragraph. If I may read on, my lord. On careful analysis of the CDR, it is seen that accused persons herein were somewhat present in and around the PO at the alleged time of the incident. Only this much, my lord.
Which one?
This side, page 115. This second paragraph. Yes. And CDR, my lord, on last occasions I had pointed out there is no CDR against my accused persons, my lord, because he was never there, my lord.
His mobile phone, it was switched off, Lord. It was switched off, so no CDR could be collected. It remained and
switch off at that point of time or soon after that?
No, my
switch
lord.
off from that time only, from that date of occurrence only. It was switch off. Switch off.
No, but see, okay, it may have been switched off from the date of occurrence, but the CDR of the dates before the occurrence, we don't know. There may be some conversation, of what is to be done, or instructions, or this or that, whatever the case may be,
before the occurrence,
leading to the actual occurrence.
Before the occurrence.
So that if you have that link with you,
it's not there, Lordship. It's not there. Only as per this record, Lordship, it was switched off from there, from the date of occurrence, and so it could not. It was inconclusive.
Where is the CDR?
Here, my lord.
This is charge sheet.
Yes, lordship. I have
complete charge sheet.
I have annexed the CDR also, my lord. A portion of the extracted CDR I have annexed, my lord. It's at page 51, my lord.
Page
51, my lord.
So your name is not here?
No, my lord.
His name is not there, Lord. There is no CDR. Admittedly, there is no CDR.
Now, go back to the CD. Where is the observation of the IO that you are involved in the matter?
Observation of the IO?
In the charge sheet. There would be some findings or observation.
his name at serial number 12 of the charge sheet, Lordship. Serial number 12 of the charge sheet. Page 13, Lordship. Page 13 of the charge sheet. Below is the page number is below.
13.
At the bottom, page 13. At the bottom, the page number is mentioned at the bottom. Page 13, Lordship. 1-3. He is at serial number 12, Poimi Sana.
This page 13 is an extra one.
No,
Not in my
page
possession, my lord.
Page 13 of the charge sheet, Lordship.
It was given separately.
Separately, I have given separately because his charge sheet is incomplete. I have given separately, Lordship, and I have flagged it also. I have given the charge sheet and the status report.
This one.
Page 13,
Yes,
serial number 12. He is at serial number 12. He has been named in the charge sheet.
Okay, name in the charge sheet, no doubt.
Yes.
But where is the evidence against him?
From page 34, I think. Page 34. No, page 35. Page 35. Page 35, issuance of warrant of arrest. Issuance of warrant of arrest, his name is there.
Okay.
And issuance of proclamation under section 82 CRPC, he also is there.
The reason why, my lord, the prosecution was initiated against the accused person, my lord, was that he was absconded. Subsequently, my lord, after appearing before the Honorable Session Court, my lord, obtaining bail, my lord, that has been regularized. So that, my lord, does not criminalize, my lord, and my lord, give hands to the prosecution to initiate me in the case, my lord.
If he is not involved, Lordship, why he was absconding? He would not have absconded if he was not involved.
It's concerning somebody's right, life and liberty, my lord, and it's my lord, randomly the people were picked up. That is the only reason, my lord.
Any statement under 164?
164.
Of any of the witnesses that you have examined, even 161 or
164, the statement of only the main accused was taken.
Not the accused, but some witness
who
has indicated that apart from others, we're not talking about others. This accused person is also part of the.
No, not there, Lord.
There must be
only the statement under 161 of the two accused persons. I have gone through all. No, statement of some of the witnesses also it was taken SI, but they have not mentioned his name. SI, WPSI.
So from where did the IO got this name? He may, irrespective of the fact that he may have absconded. He may, that would come later.
Yeah.
That would come later. Initially, there must be some information that these are the person who are part of the mob. 1, 2, 3, 4, 5, 6. So his name may figure at 7, 8, 9, whatever.
Yes.
There must have been. Where is that indication?
Lordship, only as per this charge sheet, Lordship, it is not there. It is only mentioned that it is on the basis of reliable information. It is not mentioned from whom, from where. It's only mentioned that on the basis of reliable information. That is.
This is just.
There is no specific observation, Lordship, from where the information came. From whom, from where. Lordship, in my humble submission, Lordship, since the IO has submitted the charge sheet, Lordship, in my humble submission, Lordship, let the trial court decide, Lordship, his involvement after the trial, after the
Anyway, Mr. Panthi, what you can do, as I said earlier, you just note down your points of argument,
My lord,
and the authorities.
I'll do that, my lord.
You have not brought any authorities.
I have relied, my lord. I've given 3 judgments, my lord. I've given, my lord.
Lordship, my learned friend also, he has not taken your Lordship to the impugned judgment passed by the trial court, Lordship. We'll just
That's
go.
what that was pointed out.
In fact, during my initial submission, I had referred. But here also, what was the observation made against my accused, my lord?
Yes.
That part only I have referred. Other part is not actually, it's concerned, and neither I am challenging. Because randomly, my lord, what is the observation? Observation made that, my lord, that he is a coal merchant, and directly or indirectly, my lord, the CDR collected. So it is involved. That is the only observation, my lord. Against other accused, I am not commenting at this moment, my lord. I am only concerned about my accused person, my lord. Against my accused persons, no materials in record, my lord. The law is very specific, my lord. At least some prima facie case has to, my lord, the materials has to be there to proceed with trial, my lord. Even admittedly, the prosecution has submitted, to, my lord, candidly before the Honorable Court that no witnesses nor materials, my lord, has been collected against the accused person. Only the ground of suspicion was, my lord, that he was absconded. It is quite obvious, my lord, that when the peoples have been picked up, my lord, obviously, my lord, for the sake of, my lord, the liberty, everybody would do. Subsequently, he appeared before the Honorable Court, my lord, obtained the bail, and, my lord, charges framed, voluntarily participated in the proceedings, my lord. It can be seen from the record itself, my lord.
Anyway, Mr. Harmi, you also filed your written argument with the authorities. And you can
I have submitted, in fact, if my lord allows me to rely, I can rely it right now, or my lord, if my lord permit.
Have you filed your written argument?
No, my lord.
Please do that.
I'll do that.
And refer again to
Lordship.
And Mr. Karmi,
Yes,
if you want to point out, from the charge sheet, the relevant portion, you can do that.
Yes.
Got the counsel for the parties. However, the learned counsel would submit that some time may be allowed for a brief written synopsis of the argument in written form to be filed before this court with the authorities relied upon. Accordingly, parties are allowed to do so within the next date fix. This is matter of 2 weeks.
Deeply obliged.
Deeply obliged.
Second call from supplementary cost list. Item number 1.
Please, Your Lordship. Lordship, I pray if this matter may be taken up on Thursday, Your Lordship, as the DAG had to leave the premises due to his health condition, Your Lordship.
Lordship, here the applicant herein is praying only for a time, Lordship. There is nothing in adverse against the respondent opposite parties.
Your Lordship, I can understand that, Your Lordship, but then the DAG has some important submission, Your Lordship.
Have you preferred the SLP?
Lordship.
You said you are preferring SLP. Have you done so?
Lordship, just yesterday I have received a certified copy of the petition and all of the contempt petition. So I will be transferring all this. So it will take time, Lordship. It has to go to Delhi, then the council there has asked for a certified copy. So I have applied, and yesterday I got it. So I have to send it. Then in the process it will take time.
Anyway, since prayer has been made
On Thursday, Lordship.
but otherwise there's nothing.
Yes, Your Lordship.
Yes, so nothing, no adverse, it is not affected.
It is only to allow the, because
Yes,
that is
time
all,
for-
you see, that is also his right.
Yes.
Yes.
He has a right to approach a higher court against any order passed by any lower court.
Yes.
The only hitch here is the imposition of the cost, which will expire. So it will be a contempt.
Yes, again, since I have filed a contempt against, now I will be liable for contempt.
We'll take it up on
Lordship. Since application is filed, then I have
yes,
no issue.
on pre-made by the on pre-made on behalf of the learned DSGI who is said to be in his post on grounds of personal difficulty. This matter will now be taken up on 18th, isn't it?
Yes, Your Lordship, 18.
Instead of DSGI, it should be senior counsel because the contempt matters as a private.
Okay, yeah, he is private.
Yes, sir.
Senior counsel, Dr. N. Musika. No. Fine. So,
Lordship.
18.
Thursday.